YouTube in a while. But today's, I guess, lecture is going to be on how to write a writ or an affidavit or, slash judicial notice, because they're kind of similar as far as the kind of like the intent you want to happen based on what you're filing. So the way court is supposed to be, which is not right now, is that the judge and or magistrate slash judicial officer, whether they be colored or not, because if they're colored, then they're acting in that capacity, which you're going to hold them to that capacity, and they all still take oaths to the Constitution. They're basically supposed to be just the referee, or like a neutral party, which is where you get, an arbitrator from, and, an uninterested third party. That's what a judge is supposed to be, and they're supposed to be held to certain laws, more specifically the Constitution and their oath of ethics and things like that. So since they're a neutral party, or they're supposed to be a neutral party, which is why you can have a judge or a magistrate or judicial officer recuse themselves from the bench based on just raising the question of impartiality. Since they're neutral, both parties are supposed to file documents, writs, affidavits, and motions to have the judge basically rule in their favor based on whether it be material facts, substantial facts, case-specific facts, case law, judicial notice, precedent, stare decisis, or res judicata, right? So basically think of courtroom as the chessboard. But instead of two players, it's really the judge is overseeing how the pieces are being moved and then making a decision based on how the pieces are moved. So now it's not really, it's still based on the individual player's competency and ability to play the game, but since they're so-called judicial officers, they have more of an obligation. So judges are really supposed to make their decisions off of not just the facts of each individual case, as far as material facts and substantive facts regarding, case-specific facts, but they're also supposed to make a determination off of law, which is why you'll read in the Judicial Encyclopedia of whether it be American jurisprudence or course juris secundum, you'll see where issues of law supersede issues of facts. So it doesn't matter what the facts are initially, it matters what the law is, which is where you deal with status, right? So an example of issues of law versus issues of fact would be if someone's claiming that I violated a contract, that issue of law is civil, not criminal. So they can't charge me with a criminal offense for a violation of a contract because it's civil. So that's an issue of law, and that is the status of the case. So the status also deals with jurisdiction, which when you read these definitions in any law dictionary, you'll be able to make those conclusions, and then you'll see where in court they have the appearance of doing that, but they don't actually honor the actual laws as it pertains to due process. So that's the difference between issue of law and issue of fact, which also proves that issues of law supersede issues of fact, which you can see that in corpus juris secundum. I can't remember which volume, but I'm pretty sure subsection 39. There's like 101 or like 101A volumes of corpus juris secundum, so excuse me for forgetting out of 100 books which book it is. But anyway, you'll also see, you can just Google search United States codes and you'll see that judges take an oath to support and defend the Constitution against, all enemies, foreign and domestic, and they also take an oath of ethics stating that they won't make a decision based on anyone's status or class. So the same treatment that a poor person would get is supposed to be the same treatment that a wealthy person would get. All right, but we already know that don't happen. Which is why we say it's color of law, color of authority, because based on the laws, they're not supposed to be doing what they're doing. Also, according to AmericanBar.org and again, the United States Code, all judicial officers, which an attorney and a prosecutor is a judicial officer, must adhere to all federal and state laws, which would be the federal Constitution and the state constitutions, as well as their statutes that are made in pursuant or the laws and rules and statutes and codes and ordinances that are made in pursuance to each constitution. So if they have codes or regulations or statutes or ordinances that violate either the state or federal constitution, then prosecutors and judges and magistrates and judicial officers and clerks and sheriffs and bailiffs and mayors and police and troopers, state troopers, marshals, all of these people aren't supposed to follow those things because they all take an oath to the Constitution. So with that being said, prosecutors, attorneys, and judicial officers have to ensure that no matter what happens during the proceedings, each party's constitutional rights are not being violated. And there's case law on this. You can just look that up, that judges are bound by the Constitution. They cannot go beyond powers delegated to them in the Constitution, and that they have a constitutional obligation to protect everyone's rights, whether it be a defendant or a plaintiff. So you can look that case law up, which is why, since they have that obligation, they have to adhere to the fact that issues of law supersede issues of fact. They also have to abide by all decisions that have been made by previous judges, as long as they're in pursuance to the Constitution, which is why certain decisions made by judges get overruled or overturned over time, because the constitutionality of those orders or those rulings or those decisions are questioned, which and when you look at, as an example, a civil cover sheet to open a claim in federal court, you see where it deals with jurisdiction, they ask you federal question or diversity, which that template is dealing with Article 3, Section 1 and 2 of the Constitution, talking about, the law and equity of the United States, and dealing with diversity, citizens or subjects of a foreign nation, citizens of different states, and states versus their own citizens. Those are supposed to be dealt with in federal court, which is why you'll see diversity and federal question on the civil cover sheet. So with that being said, knowing how the game is supposed to go, dealing with due process, the principles of laches isn't supposed to exist in an actual courtroom. You can get away with that in quasi courtrooms or quasi tribunals, quasi courts. So you can get away with that, and maybe arbitration, but that's not supposed to be allowed in actual judicial courts, because of the 10th Amendment stating that nothing in the Constitution is supposed to be construed to deprive anyone of their rights, and anything not mentioned in it doesn't deprive people of their rights. In fact, it reverts back to the states or to the people, which the state and the people are supposed to be the same thing. So with that being said, let's talk about what an affidavit is. An affidavit is basically a declaration of facts. So when police write their reports, that is supposed to be an affidavit. An affidavit is supposed to have a wet ink signature, and affidavits cannot be made under threat, duress, and coercion. In fact, no contracts can be made under threat, duress, and coercion. So an affidavit is basically a declaration of facts. A writ is a command. So how a writ is used, it's not just used by judges, it's used by anyone. Anyone can issue a writ. So as an example, if let's say, federal rule, if the federal rule of evidence states that, evidence cannot, based on the exclusionary rule, that evidence cannot be, evidence is inadmissible if it's obtained without a warrant, right? You would send a writ to the courts, not a motion, because a motion is a request. You would send a writ to the court to command the court to strike the evidence from the record based off of what the law is. So you're not filing a motion to argue about, the validity of the motion. No, you're simply putting them on judicial notice, basing it off the law, and commanding that the courts do what they're supposed to do according to their own laws. So that's the difference between an affidavit and a writ. And you also just heard me mention judicial notice. So basically, judicial notice can be explained as something that cannot be disputed and does not need to be proved. So as an example, today's Wednesday. I don't need to go to a calendar and show you that today's Wednesday. It's Wednesday. Another example of judicial notice is that the sun is hot. You don't need to physically go there to feel it. You can feel the sun beaming heat on you. So that's an example of judicial notice. Also, any mention of any judicial officers, and by judicial officer that includes judges, magistrates, clerks, bailiffs, prosecutors, attorneys, all of them are considered judicial officers by definition. If you're reminding them of their job based on what is written, that is judicial notice, right? That can also be explained as stare decisis. Sellouts call it stare decisis to try to confuse you in your mind by simply understanding the word stare, which means to look at, decisis, which means something decided. So when you reference case law, which is also res judicata, and I'll explain the difference in a second. When you reference case law, when you reference the Constitution, when you cite the Constitution, you cite case law, and you cite any state or federal laws that are made in pursuance to the Constitution to argue your point, that is considered judicial notice, and they cannot be disputed, right? So stare decisis means to stare fixedly at a decision. So the Constitution, by definition of stare decisis, which means to look fixedly at something already decided, the Constitution was already decided. So we use that in court. We look at it in court when we're trying to make arguments or decisions, which is stare decisis. Res judicata is basically, for lack of better words, is basically the judicial branch's way to quote unquote create laws without having to go through the legislative body, as long as those laws are made in pursuance to the Constitution. Well, they're basically decisions. So what gives the judicial power the authority to do that is Article 4, Section 1 of the federal Constitution, dealing with full faith and credit given to each state of the Union, and that the public acts, works, proceedings, and judicial opinion shall be respected in every state, which is where you get the common law from. So when you hear Moore's mention the common law, that includes the Constitution, which the Constitution, Article 6, includes the Articles of Association and the Articles of Confederation, as well as all constitutional decisions made by competent judges with, prescribed and competent jurisdiction. So that's basically the difference between stare decisis, res judicata, and judicial notice. But all of them have a fine line of similarity because you're basing it off of what was already decided, what was already said previously. Which, when you're dealing with res judicata and stare decisis and judicial notices, you're dealing with something called, there's multiple names for it. Interlocutory estoppels, preliminary injunctions, prohibitios, estoppels. It's basically dealing with claim preclusion, issue preclusion. It's used to help save time, so that way you're not going to court for the same type of arguments that were already decided years ago, which you'll hear in the video that we did with an attorney, that she kept referencing how, oh, you're referencing a case from the 18 something, as if it being old doesn't matter. But then when you reference the Constitution is older than that. So what they try to do is they try to trick you about, oh, well, it's old, so they won't necessarily say you can't use it, but they'll try to imply, they'll word the sentence to the point where it makes you think that you can't use that case law because it's old. But if you've ever helped anyone in court or have ever been to court, you'll see where both state and federal courts, even traffic courts, family courts, they all use res judicata, and more often than not, when they reference a case, they'll put in parentheses the date that decision was made, and they're often old decisions. So that's what res judicata is. That's what stare decisis is. That's what judicial notice is. That's what what else? I just go over an affidavit, a writ, how they're used, and basically what's supposed to happen in court. So without going into, I kind of have to go into details of due process, but I already have information written on that you could pay for, and to save time, I'm not trying to go into all of that. But anyway, if you're ever in a situation where you're in court and you have a feeling that your right to due process has been violated, there's a 99.9% chance that your right to due process has been violated, because common law is based on common sense. Can I use your video on my site? Of course, bro. Come on, Will Turbot, what are you doing? This is a First Amendment video. So there's an ancient Moorish principle that our ancestors used to have. And it basically goes something like this. Something that is created for the common good of the people no longer belongs to the creator. It belongs to the people. So the person that invented the toilet, who died years ago, that's no longer his. It's the people's. You know what I mean? So anything I put on video, anyone can use. The police use my videos without asking me. They, you know what I mean? They wrote that in their police report that they use my videos as evidence. So, of course, the people can. So if, again, like I said, if you feel like your rights have been violated, there's a 99.9999999% chance that they have been violated. And basically what due process is essentially the proper sequence of events in order for anything to be made against you in court in the first place. You know what I mean? Whether it be probable cause, whether it be an actual, I'll read this. Dealing with, you know, because Moore's will reference case law saying that in order for a crime to exist, there must be an injured party, which my bird's agreeing, which also relates to civil issues. In order for a civil infraction or a civil issue to be brought against you, there has to be an injured party. It doesn't have to be a physical injury. It could be injury from a contract. It could be injury from most of the time it's a contract or some type of agreement that you violated or whatever, or a fine or something like that, which is dealing with contracts. So both civil and criminal issues must have someone bringing claims against you, which 99% of the time, you don't even see the person bringing charges against you. It's the state, which doesn't even make sense because according to, and they don't have the jurisdiction to do that. Proof of that is Article 3, Section 2 of the Federal Constitution, which states that in controversies at which the state is suing its citizens, which would be the state of versus you, that is supposed to be in federal court according to the Constitution. But guess what? The people don't know that because they don't even read the document that basically exists to protect them. And then once you get an attorney, you admit the jurisdiction of the court and you grant the court jurisdiction over you, so that way they can basically do whatever they want once you get an attorney because you gave them permission to do so. And if you look up the definition of improper persona, if you look up the definition of pro se, if you look up the definition of civiliter mortuus, info life, and an appearance versus a special appearance, you'll see what I said to be true. So, dealing with the fact that in order for a civil or criminal issue to exist, there must be an actual injury, we're going to use Black's Law Dictionary 5th edition, which I have Black's Law Dictionary 4th edition signed by retired Chief Justice Frank J. Williams of the Rhode Island Superior Court, who re-renovated the entire law library, which they have Ballantyne's, Black's Law, Bouvier's, and other law dictionaries there. But they don't have Black's Law Dictionary 4th edition at the Rhode Island Superior Court, which is interesting to me. But anyway, to prove that in order for a crime to exist, we're going to look up the definition of corpus delicti, which means body of the crime or injured party. It's Latin, so we're going to do that. Corpus delicti or delicti. So, you know, tomato, tomato, potato, potato. We already know that the English language is derived from multiple languages. So, you know, when you're dealing with the science of phonetics and tildes and accents and umlauts, vowels are interchangeable. So you already know tomato, tomato, stare decisis, stare decisis, corpus delicti, corpus delicti. It's the same thing. Don't let them try to trip you up in court, which is what they try to do. Corpus delicti. The body of a crime, the body or material substance, which would be for civil issues and or criminal issues, upon which a crime has been committed. That is to say, the corpse of a murdered man, the charred remains of a burned house, in a derivative sense, the substance or foundation of a crime, the substantial fact that a crime has been committed. The, quote, corpus delicti, unquote, of a crime is the body or substance of the crime, which ordinarily includes two elements, the act and the criminal agency of the act, which is State versus Edwards. So you can use that State versus Edwards in court to argue that in order for a crime to exist, there must be an injured party. So if I'm going to court day after day after day and there's no one claiming that I did something to them, then there's no injured party. If they're claiming that you violated some statute, then there's no injured party because all you did was violate words on a book, which no one can prove that. You know what I mean? And of course, according to the decision of Cruden versus Neal, which is made by a judge, not me, it states that all men are independent of all laws except those prescribed by nature. He is not bound by any institutions formed by his fellow men without his consent. Which means you can't violate statutes unless you agree that the statute applies to you. And of course, if you actually commit a crime where you beat someone up or you stole something, then of course the jurisdiction applies to you because you actually committed the criminal agency, the act itself, and you have the substance that was stolen. So that in itself grants jurisdiction. But when you're also dealing with jurisdiction, you have subject matter personam and territorial jurisdiction, air and sea jurisdiction, which the European colonists will try to claim territorial jurisdiction, even though this is not their land, and they admit that. So don't let them do that. So that's basically that. So now, application of this happening in real life, which is basically the meat and potatoes of this, is proof that it works. So here is here's a case from Rhode Island Superior Court, Providence County. I think it's backwards, but oh well, deal with it. So this is dismissal for Rhode Island Superior Court, Providence/Bristol County, case number P2/17-0106 alpha. It says the state would be unable to sustain its burden of proof at trial, therefore this matter is dismissed. And then you'll see, you can actually see that is a three-dimensional embossed seal. And you can see it on the back too, that this is embossed from the Rhode Island Superior Court. And you'll see the date is 2017, which you'll often see the date in the actual case number itself. Right? You see Rhode Island, State of Rhode Island versus Lissette. So I'm going to show you the charges before I show you the affidavit, because however you're going to write your writs and your affidavits is going to be based on what's brought against you, not based off of your belief and what you feel about the case. That doesn't fucking matter. What matters is what they're bringing against you and the issues of law, right? So this is the case number right here, P217-0106A, which matches the dismissal, right? This is from State of Rhode Island and Providence Plantation, State of Rhode Island, Providence Superior Court Criminal Information Number P2/17-0106A, Lissette, State of Rhode Island versus Lissette Aries, criminal information. The Attorney General of the State of Rhode Island, count 1. The defendant of Kent County on about the 11th day of May 2016 in the city of Cranston and the county of Providence did obtain MoneyGram being of a value of over $1,500 from Michael Randolph, designedly by false pretense with intent to cheat or defraud said Michael Randolph in violation of subsection 11-41-4 and subsection 11-41-5B of the General Laws of Rhode Island, 1956, as amended, reenactment 2002. Count 2. The Lissette Aries, Lissette of Kent County on or about 11th day of May 2016 in the city of Cranston and the county of Providence, standing in a position of trust and confidence, did knowingly by deception or intimidation obtain or use the funds, assets, or property of Michael Randolph, he being a person 65 years. Can you give me water, please? 65 years or older, with intent to temporarily or permanently deprive Michael Randolph of the use, benefit, possession of the funds in violation of subsection 1168-2 of the General Laws of Rhode Island, 1956, as amended, reenacted 2002. Right, so that's the charges. So count 2 is predicated on count 1. So count 1 is obtaining money under false pretenses. Count 2 is defrauding an elder based off of obtaining money under false pretense. So count 2 would not exist without count 1. So knowing that, as you're formulating your argument, your writs, your affidavits, you would challenge mainly count 1. And once you basically knock count 1 off the table, you would basically state, since count 2 is predicated off count 1 and I've completely demolished count 1, count 2 don't even fucking have any standing, which is status, right? And then you'll see here, State of Rhode Island and Providence Plantation's criminal information, State of Rhode Island versus, it says the defendant, and then it says arrest number 16-37086 Oscar Foxtrot /16-44210 Alpha Romeo. right? And I'm gonna hide her birth date. All right, so the reason why that arrest number is important is because when she came and asked me for help, I didn't have the case number, so I put the arrest number on the affidavit. I wrote the entire document. And you'll see this was an actual real case. So, excuse me as I gotta sip this water, I'm dehydrated. So, if you study before you get into trouble, well, I shouldn't say you get into trouble, before charges are brought against you arbitrarily, without warrant, without cause, without due process, or if you're interested in helping other Moors, it would be in your best interest, so as they say in the Marines, it would behoove you to study before anything bad happens, which is, just prepare, which Prophet Noble Drew Ali said, get ready before you're made to do so. So prepare. So since I've been studying, I know, one, Federal Reserve notes are not money based on the legal definition. Two, there has been no money in circulation since 1913 and or at least 1933. I also know that based on the United States Code, USC, Title 12, United States Code, subsection 411, the obligation of all Federal Reserve notes belong to the United States, meaning the debt of the note belongs to the U.S., not the people. I also know now, but at this time I didn't know this specific part, that Craig versus the state of Missouri ruled that the defendant, Craig, did not have to pay the state of Missouri any amount of money because the state never gave him money. They gave him Federal Reserve notes, or a promissory note, which is the same thing. I also learned later in Don E. Williams versus the IRS commissioner that a note, even when payable on demand, is still only a promise to pay and not payment, which means no one can ask you to pay and a promise to pay. And for the sake of tax purposes, it's considered a conditional payment, because according to the law, in order for a contract to be valid, there must be something called legal consideration, legal or lawful consideration. So legal consideration would be something considered of value in the eyes of the law. Lawful consideration is something considered of value in the eyes of the law. Legal consideration is something considered of value between the parties. So since it was decided in Don E. Williams versus the IRS commissioner that Federal Reserve notes and promissory notes, which is the same thing, or private commercial paper, which is the same thing, are considered conditional payments because it's under the condition that you are recognizing it and they're recognizing it as something of value. But once you stop recognizing it as something of value, then they can't force you to pay using it. Also, proof that in the eyes of the law, Federal Reserve notes have no value exists in House Resolution 5404 of the United States Congress, March 22nd, 2018, if I'm not mistaken. They stated that the United States dollar has lost 96% of its purchasing power, which means it has lost 96% of its value, which means $1 is really 4 pennies, $100 is really $4, which means it has no value. Since it's not backed by anything based on the Federal Reserve Act of 1933 and the creation of the Federal Reserve in 1913, which is why 12 USC 411 exists, telling you that the debt belongs to the U.S. So knowing that, I know that, one, money's not real. Well, Federal Reserve notes are not money, so they can't charge you with obtaining money on a false pretenses. They can only charge you with obtaining Federal Reserve notes under false pretenses, which, according to any law book you read, it'll tell you notes are not money. So Federal Reserve note is not money. So you'll see where a lot of people, even if you go to like pawn shops and things like that, they'll have old U.S. Treasury certificates, which those things used to be backed by silver. And even that's not money. That's just a circulating medium that represents the intrinsic value of money, which the money is actually somewhere else. So the gold and silver would be in the actual treasury, and the paper that's circulating would be representing the value of that. So that way you would take that certificate, you would go to the treasury, and they'll give you silver or gold based on the amount that you had. You can't do that with Federal Reserve notes, which means they have no value. Also, based on the counts, I know that in order for a crime to exist, there must be an injured party. And also, just to prove that state courts don't have jurisdiction to to charge their citizens or go against their citizens and then they be the judge is the Constitution itself, which all the states of the European Union, known as the United States, agreed to and ratified. It states under Article 3, it says, I'm going to read Article 3, Section 1 and 2. The judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. So the district courts, so when you see the United States District Court for the District of Massachusetts, United States District Court for the District of Connecticut, for the United States District Court for the District of Florida, those are the courts that Congress ordained and established, as well as the circuit courts, which would be the courts of appeals on the federal level. So those courts, according to the Constitution, have Article 3 powers, right? But we're going to know based on the coup in 1861, which the attorney that we had a conversation with agreed that there was a coup in 1861. They no longer have that actual constitutional power. But anyway, I digress. The judges of both the Supreme Court and inferior court shall hold their office during good behavior, blah, 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 blah. So, right? So the absolute power, the constitutional power, or the judicial power of the United States rests in the Supreme Court, the district courts, and the courts of appeals, which is why when you file a civil claim or a federal claim in court, they'll ask you, is it a federal question dealing with Article 1, Section 1, or a issue of diversity, which also Section 2 in part deals with the federal question, and Section 2 deals with the issue of diversity, which translates to the United States Code, Title 28, subsection 1131, which is federal question, and United States Code, Title 28, subsection 1132, which is the issue of diversity. So Section 2 of Article 3 states that the judicial power shall extend to all cases in law and equity, which is dealing with the federal question, arising under the Constitution, which is the federal question, the laws of the United States, which is the federal question, and treaties made, which is diversity and federal question, or which shall be made under the authority to all cases affecting ambassadors, diversity, other public ministers and consuls, diversity, to all cases of admiralty and maritime jurisdiction, diversity, to controversies to which the United States shall be a party, to controversies between two or more states, which is diversity, because every state of the United States European Union maintains self-autonomy and maintain their independence, which means it's separate jurisdictions. So, of course, the federal court has to deal with that because that's what they agreed to. Right? Between states and citizens of another state, between citizens of different states, and between citizens of the same state claiming land grants of different states, and between a state or the citizen thereof. So if it's the state versus you, that's supposed to be heard in federal court, and they're not doing that. So this don't just apply to Moors, this applies to Europeans too. If you think you're a state citizen, a U.S. citizen, caps, lowercase, it don't fucking matter. If you claim that they're your government and it's the state of versus you, that's supposed to be in federal court. And if the states are claiming that you're a citizen and it's the state of versus you, that's supposed to be heard in federal court, according to Article 3, Section 2. And then, of course, it states, so between a state or citizen thereof and foreign states and citizens or subjects of foreign states. So if you're a Moorish American, not a U.S. citizen, and it's the state of versus you, it's supposed to be heard in federal court. If you're a U.S. citizen, European Albion, or so-called black, and it's the state of versus you, that's supposed to be heard in federal court. Right? So knowing that, knowing all of that, because you can't just know one thing, you're like, oh yeah, I got this. No, it don't work like that. You have to know how it works, how the gears grind, right? Knowing all of that, I was able to formulate this argument. And this is basically how that form of thinking, that mindset, that consciousness, that status, that mental competency is what helped me formulate this affidavit, quo warranto and information, right? Which is the judicial notice. So going back to high school, basically, and what I learned in high school was, and I went to a public high school, was that in English class, when they teach you to write a paper, you have your thesis, you have your supporting arguments, and then you have your conclusion, which is how I have always written my legal documents or lawful documents, whatever you want to call it, which is how I write my books like that. I write everything like that. Even my posts sometimes on social media, I write it like that. And when I'm talking about anything about law and civics and jurisprudence and history, I formulate my thought patterns like that. That's like basic writing skills, I guess, in school that they teach. So your thesis is basically your idea, your theory of how you're innocent or how you want to formulate this affidavit or why you're right. Your supporting arguments would be the res judicata, the stare decisis, the judicial notice, the House resolutions that support what you're saying and things like that. Your conclusion is basically saying, based off of the res judicata, stare decisis, material facts, substantial facts, the courts must rule in my favor because of those things. And then at the end of that, you would attach, or you can attach, or you can put it in after every point. You can attach your exhibits or your amendums or addendums, whatever they're called, the Latin word for it, where you just add your exhibit A, exhibit B, exhibit C. And what I've started doing was I created like a cover sheet explaining what it is. So it'll say like page 1 to 3 is my argument. Pages 4, 5, 6, 7, 8, or I wouldn't even do that. I'll just put exhibit A is, I printed, Criminal Resource Manual 1508, and I put that, I have the actual document itself, but I put exhibit B would be, or exhibit A would be Criminal Resource Manual 1508, stating that nationality cards are a superior form of identification, supporting my arguments made in my affidavit. So that way, when they look at it, they already know, okay, I'm associating that argument with that. And it's not really for them because they're obligated to know law. It's really for anyone looking, anyone reading, whatever. You know what I mean? So that's basically how I structure it. And you can literally make an affidavit as long. You can make a writ or whatever, a warrant or whatever you want to do, whatever you want to call it. You can make that as long or as short as you want. There is no, what I mean. Sometimes the courts will ask you, as an example, if you ever get to the superior court, Supreme Court, United States Supreme Court level. And you'll see the writ of certiorari and what's required for that. I only helped one person with it so far. Like a glossary, exactly, or index, or a table of contents. It's all the same shit. We learned this in school. The Supreme Court, United States Supreme Court, will ask you to keep your filings to them no longer than like 15 pages or some shit like that, because they have to read everything. So, you know what I mean? So get to the goddamn point. Because some Moors will file like 200-page documents and then ask me to review it. Like, nah, I'm not doing that. No, hell no. If you're competent enough to create 200 pages, you don't need me. But Moors, they just copy and paste shit. You know what I mean? But anyway, so like I said, affidavits and all this shit can be as long or as short as you want it to be. So here's what we wrote to the court. We put the certified mail number because we mailed it to the court and the attorneys. And then here is my signature and thumbprint and her signature and thumbprint. And then at the bottom is some res judicata that we cited. So, it's only 2 pages. And I already showed you the dismissal. So, I'll read what we wrote. So, y'all remember the charges, right? Obtaining money under false pretenses and exploitation of an elder. So, this is what is written. It started off with Michael J. Zarilla and Amy Argarios. There's a lot of Italians out here. Of Providence County Superior Court Deputy Clerk in Ray, which means in reference to State of Rhode Island versus Lisette Aries, and then I put the arrest number because I didn't have the case number at the time. And then Exhibit A, affidavit of fact, quo warranto, and information. Excuse me. Notice to the agent is notice to the principal. Notice to the principal is notice to the agent, which translates to UCC 1-202. In an attempt, so this is what we wrote to the courts. In an attempt to ensure that I'm dealing with a legally and lawfully competent court with prescribed jurisdiction according to Article 3 of the Constitution for the United States of America, I rightfully demand to see the judge's oath or affirmation to support and defend the Constitution in regards to this matter. It has already been declared in Clearfield Trust Company versus the United States case in 1942 that governments descend to the level of a mere private corporation when dealing with suits in regards to private commercial paper / Federal Reserve notes and securities, which would be checks. To ensure that this is not a commercial court, it must be clearly established for the record that the judge appointed to this case is an Article 3 judge. I put a typo, it says are an Article 3 judge, which means you can still write this stuff and have typos and still have the effect that you want it to have. Because there's case law that states that grammatical errors or informality, that's a word, right? Informality of documents does not negate the legal effect or does not negate contracts. You know what I mean? So don't even worry about that. If, in fact, they are an Article 3 judge, being so, they have a constitutional obligation to ensure that my constitutionally secured right to due process is not violated and know that they lawfully and legally do not have jurisdiction in this matter. Therefore, it must be thrown out, and any attempt to adjudicate on this matter is unlawful and unconstitutional. Therefore, is an act of treason against not only me, but the Constitution and the American people. So I always had this issue of run-on sentences in high school, and this is a run-on sentence. But still, it worked. As mentioned in the Owens versus City and Stone versus Powell cases, state courts like federal courts have a constitutional obligation and are to protect the people from encroachment of their secured pre-existing rights and liberties. So there's two instances of stare decisis and res judicata, well, three really. Owens versus City, Powell versus Stone versus Powell, and Clearfield Trust Company versus the United States. So far, already three. And you see how my argument was that they don't have jurisdiction, and I proved it over the issue of Federal Reserve notes, and I proved it with case law. Then I stated that they have an obligation to protect this person's rights, and then I proved that with case law. So my thesis was you don't have jurisdiction over this because it's not real money, and then the supporting argument is the case law, and then the thesis is the second point or second thesis is you have a constitutional obligation to protect my rights, and then the supporting facts or arguments is the case law again, which is exactly how you write your papers in high school. Considering it has not been proven that I have obtained any money, as the only lawful money is gold coin or its silver equivalent, I cannot be charged with obtaining money on a false pretenses, unquote, because that's what the charge is. Where is it? Right here. Obtaining money on a false pretenses, which is the actual charge. As gold has not been in circulation since the Federal Reserve Act of 1913, governments only have a say in regards to the strict and technical definition of the word money, gold or silver. If I'm being charged with obtaining Federal Reserve notes / private commercial paper, then this must be a commercial court, to which jurisdiction can only be established if there's a contract on the record that I have abridged or am supposed to have violated, to which the corpus delicti, injured party, must be present to ensure that he / she is in fact the person who is making claims against me, to which his / her sworn affidavit of those claims must be signed by them and entered into the record. Considering there is not a human being present to ensure and attest to the claims made against me, bearing witness to the said signed affidavit of claim made against me, then in honor and alignment with the 5th and 6th Amendments, stare decisis, which state I have the constitutionally secured right to face my accuser and ensure that I have the right to due process of law, then I demand, no motions, no request, demand that the alleged charges of obtaining money on false pretenses be dropped, dismissed, or otherwise acquitted, considering there is no grounds for that charge to be held against me, as an injured party and contract have not been properly identified. The alleged offense of exploitation of an elder must be dropped as well, considering no lawful or legal money was taken from anyone, and the alleged accuser is not present, nor is there a signature on any alleged accusations linking it to a living man or woman. Thus is prima facie, or prima facie, how the attorneys like to say it, evidence that these charges are artificial, leading me to the conclusion that this is in fact a commercial court to which all parties involved except me are co-conspirators in an attempt to extort finances from me, thus chargeable under Title 18 U.S.C. subsection 241, conspiracy against rights, and Title 18 U.S.C. subsection 880, receiving the proceeds of extortion, et alia, which means and others. If the injured party is present, then I rightfully demand that Michael Randolph and Phyllis A. Randolph present themselves, properly identify me as the alleged defendant, and make claims to the signed affidavit of claim made against me. If they are not present, nor their sworn affidavit of fact, affidavit of claim made against me, and or their authorized representative with signed agreement between the aforementioned alleged injured parties and their agent entered into the record, then those alleged charges must be dropped. There's not one document with Michael Randolph and Phyllis A. Randolph's signature on them, and that alone stands as prima facie evidence to the violation of my right to due process, as the sworn and signed affidavit of claim made against me, which moved the courts, must be presented and identified for the public record. To be submitted on the public record as Exhibit A, whereas I state, proclaim, and declare the following to be true, correct, not misleading, and not intended to be presented for any misrepresented, colored, or improper purposes. I am, she signed, I signed. And then we put consideration. An instrument is deemed in law filed at the time it's delivered to the clerk, regardless of whatever the instrument is filed marked. Biffle versus Morton Rudder. Uncontested allegations in an affidavit must be accepted as true. Morris versus National Cash Register. A judge ceases to sit as a judicial officer because the governing principle of administrative law provides that courts are prohibited from substantiating their evidence, testimony, record, arguments, and rationale for that agency. Additionally, courts are prohibited from substantiating their judgment for that of the agency. Courts and administrative issues are prohibited from even listening to or hearing arguments presented or rationale. ACIS versus U.S. If this is a criminal matter, there must exist an injured party, of which I would be obligated to make remedy to. If this is a civil matter, there must be an injured party or property, even onto a preponderance of evidence. If this is an administrative court, traffic court as well, there must be an injured party as defined as the established rule of law, submitted in Exhibit A, Board of Trust versus Olson. And you'll see the case was dismissed, which is what I showed you earlier. This is a copy. This is the actual one that's sealed by the court. You see that three-dimensional impression? And again, the reason why the courts can't say that they don't know who I am, because this was in 2017 with my free national name on it in 2017. So yeah, that's basically it. That's how you write an affidavit or a writ. Congratulations. Let me see if there are any questions. There we go. Let me see. There's probably a lot. Yeah, if a job doesn't pay you, you are a victim, yes. And they violated a contract, which is a civil issue. I'm just looking at comments right now. So I want you to realize in the comment that in the comment section, someone said so many incorrect and incomplete interpretations of the law, yet I showed you proof that the case was dismissed. So why is it that when I asked to see the judge's oath and made all these arguments in the court and asked for evidence, and the court said they would be unable to sustain burden of proof. Why did they dismiss the case? Because if you speak to this lady, she'll tell you that the case was going on for at least 2 years, 2 or 3 years, and we filed one document and they dismissed it in 2 weeks. So don't listen to these people in the comments. They have no proof of claim. Can all of this apply to Jamaica? Common law can, but not specifically referencing U.S. courts, but common law, yes. Common sense, yes. If money is not legal, how are people paying you for your incorrect information? This is a free video, so they're not paying me for it. And then again, if you reference Don E. Williams versus the IRS Commissioner, Federal Reserve notes are considered conditional payment. They're not absolute payment. It's conditional, which is how the fiat monetary system works. It's considered conditional payment. You're really bartering. There's no payments, which the United States Supreme Court already stated that in Don E. Williams versus the IRS Commissioner. Where can I find the case law you used? I didn't file a motion, first of all, but you can Google it. If you look up caselaw.finelaw.com, you can search it. If you look up Justia, I'm pretty sure it's .com. You can look up stuff. If you look up, I think it's case law text or something like that. Google that, and you'll see. You could read all the cases you can imagine. I'm still reading questions. It's just because people are going to watch this video over, so they're probably like, why is he just staring at the camera? I'm reading questions. All right, since there's no more questions, peace, study. Never arbitrarily accept what anyone's telling you without proof of claim. So to prove that I at least know a little bit about this information, at least, is proof that the case was dismissed. So it's not just me on here talking about, oh yeah, I know law, without proof of it actually working. If you want more proof, you can go to riseofthemoors.org, click on public information. It's all free. You don't have to pay for it. Click dismissed. You'll see driving without license, without registration, without tags, wrong plates, speeding. You'll see all those cases dismissed, and you'll see this case up there as well. So again, riseofthemoors.org. With that, I'll say peace. Don't be discouraged based off anything that you see happening to any Moors, because the way the system is designed is they want to discourage you from fighting back, which 99% of the time is just with your voice. You're literally just arguing with what you know and the information, but that's going to begin something powerful for our people, so they don't want you to have that, which is why they're going to try to, you already know what it is. Look up COINTELPRO. That's what they do, to discourage people from leaning towards the truth. That's why you see people in the comments, they're trolling. They're just making arbitrary statements with no proof of claim. You'll see even when we were on the video call with the two attorneys, that they never had any proof of anything. It was just filibustering. They were just talking with no proof of anything. And more often than not, if you actually think about what's being said by these people, you'll hear how they contradict themselves. And you'll see in the video where I used her own school of thought against her, and she disagreed with it. It was like, how can you disagree with your own thought pattern? That's called cognitive dissonance. But anyway, peace, Moors.